Mr. Bartman.
I'm sorry?
Aren't you going first? Yeah.
I'm Attorney Bartman.
Yes. I
Yes.
said Mr. Bartman. And then
Okay, thank
I just
you.
looked to...
Good morning, Your Honors. May it please the Court, I'm Frederick Bartman. I represent Ryan Natu, and I wish to first thank you for accepting his petition for further appellate review. I wish to focus on what I think is the incorrect ruling of the appeals court. In the first instance, the appeals court seems to have placed almost exclusive weight on the fact that my client's personal belongings were left in a quasi-public or public place, namely at the end of the driveway by the side of the road, and that therefore, once he had been arrested, any reasonable expectation of privacy had vanished. And I would argue to Your Honors that is an oversimplification, if not ignoring, of a number of other factors that had preceded his arrest. And as the Court knows, the mere fact of somebody's personal belongings being in a public or quasi-public place does not end the analysis. It's obviously a factor, but it's not the only factor. And here, you have, I think, undisputed evidence that just moments prior to my client departing from his property, this had been his...
Wait a minute, from whose property?
Well, from the property at which...
From the property.
The property.
Okay.
And in which the Court found, based on the evidence, that this was a place that he had resided with some regularity, I think was her words, and it was based on the evidence put forward by several witnesses, really for both the Commonwealth.
But not with the owner's permission, right?
Not the current owner,
Yeah.
who had been there for a week. And understandably, this was really, while it's beyond my own legal purview, clearly an instant or summary eviction where my client goes from being somebody who resided at this home with some regularity to somebody that's told, get out. And
Well, he was a trespasser, wasn't he?
probably.
Okay.
And at that moment, he's a trespasser. He's no longer able to use this location as a home or a residence, albeit with regularity or not. He packs his belongings in what we can call in our vernacular luggage. These are his personal belongings. It's undisputed. He's got a large television set. He's done as instructed by the new owner of the property, as endorsed by the police, that he should take his belongings and get them out of the property and don't come back. And with everybody's knowledge, he not only does that, but he makes arrangements to...
Weren't these in plastic trash bags?
Yes, they were, Your Honor.
Not luggage.
No, I said that with meaning in the generic sense that with regard to Mr.
And
Natu...
He leaves them at the end of the driveway, as I understand it, on the road, or near the road.
Yes, Your Honor.
Or street, whatever it is. And across the driveway, there's some other plastic bags with trash in it, trash in them.
I believe that there's a hybrid of things on the other side of the road. There are some Tupperware containers with stuff that the prior owner was going to be moving. There are some plastic bags. There are some trash bags. I think, but I think that...
Is there any question that the police know that it's his property that's in those trash bags?
I don't think so, Your Honor.
There's a question about whether they knew somebody was going to pick it up. I mean, Ms. Petras says that, but I think, but there isn't a question that they knew it was his property.
That's correct.
But we see this phenomenon all the time where people, put the trash bags down the end or other objects, discarded lamps, all that stuff. And people coming by pick them up. Right?
Sure.
Looking
Sure.
for 5 cents back on the bottles and all that kind of thing.
Sure.
So where's the expectation of privacy in that?
Sure. I think the
Objective, I mean.
in this instance, Your Honor, the expectation of privacy comes in these being trash bags that are being used as luggage, and that they're the only containers that are available to my client under the circumstances of this particular case.
Well, the appeals court, which of course reached a different, ruled against your client, said it was paying no attention to the fact. In fact, explicitly went out of its way to say the fact that these were plastic quote, trash bags. They were plastic bags. Played no part in its reasoning, right?
But it's got to be twofold. It's got to be a subjective expectation, which I would think he had, but it's got to be objectively reasonable, and I don't see how it is, in view of what we just discussed, that this is open to any Tom, Dick, and Harry to look into these bags, or feel the bags, or take the bags, or whatever.
Well, and this is what the appeals court focused on, and
What's wrong with that?
well, because I think what the appeals court said is, under the circumstances of this particular case, because there was a vulnerability, somehow all of the steps that he had taken that otherwise had created an objective expectation of privacy vanished. This wasn't somebody who took no steps whatsoever to safeguard against what Your Honor is positing as a possibility. This is
Isn't the key thing here that the police knew that these bags contained his personal belongings?
I think so, Your Honor. I think
And that he was not abandoning them?
clearly, and the appeals court said this is not an abandonment case, and the appeals court also said this is not a trash bag case. This is somebody who took a number of explicit steps to protect his expectation of privacy in the most important items.
But it is a case, at least I think it's the Commonwealth's position that the motion judge was wrong to say that the police actually knew that somebody was going to come pick them up. So, I mean, so
Well,
if that's,
sure.
do you disagree with that?
I do, for two reasons. One, I think there's ample evidence in the record that the police knew, and second, the appeals court said it in their opinion.
Knew
Oh,
someone was going to pick it up?
The appeals court noted that there was a controversy, but basically said, essentially, we assume the police knew, and that doesn't make a difference here.
Yes, Your Honor. And toward the end of their opinion, they went on to recite the number of things my client did, and I believe in that paragraph, without condition, they indicate that the police knew that my client had made these arrangements.
Well, didn't Officer Crevier, I think that's his name, didn't he do later what the police probably could have or perhaps should have done at the moment the defendant was arrested and taken to the police station, which is to impound what they believed was his property for safekeeping and took it to the police station? Isn't that why the Officer Crevier took the bags to protect? Because the new owner called and said, hey, the bags are still there, we don't want anybody back. So he went and he took the property for the defendant on his behalf and brought it to the police station.
Well, I would argue that that is an after-the-fact justification as opposed to what he actually did or what motivated him to go take those bags. And there's nothing in the record that supports that that's what he did. It can be left open to debate or maybe even conceded that...
How does it hurt you? That the police, that Officer Crevier impounded those bags for the benefit of the defendant?
Because he didn't do that for the benefit of the defendant. If he had done that for the benefit of the defendant, Your Honor, when he got that phone call from the new owner, Mr. DiMarzio, the first thing he would have done is turned to my client and said, what do you want done with this property? Or he would have had an inventory filled out in accordance with the written inventory policy. Or he would have inquired of the other officers or he would have responded to Mr. DiMarzio's initial phone call.
I thought you were arguing, I thought that the thrust of your argument was that he violated the inventory policy of the police department.
No. The thrust of my argument, Your Honor, is that my client had an objective expectation of privacy, one that society is prepared to find to be reasonable under these circumstances.
But that doesn't prevent him from doing an inventory search, does it, in these circumstances?
When my client was arrested, he had been in possession of his personal property and those items had been taken with him and inventoried, probably I'm not arguing before you right now. But that's simply not what happened. He's standing by the roadside, there's trash bags, the equivalent of luggage, and his television set, and arrangements to continue to, in fact, improve upon his expectation of privacy. He's moving from one home to another, and he's arrested. He's taken away by the police. And to convert that into an inventory search or something being done for the benefit of my client, I think belies what actually happened in terms of what Officer Crevier did. Because what Officer Crevier did is he received the phone call from Mr. DiMarzio, required no further elaboration or explanation, didn't involve my client, it didn't involve a written inventory in compliance with the policy at the time. He simply went back and engaged in a general search of my client's property.
Would you say, you take the position that it was reasonable for your client to assume that he had an expectation of privacy? That was reasonable.
Yes.
Well, but the bags are out there on the street. They're open to anyone who comes by. There's trash across the street.
Right.
I mean, and the police didn't force him to put the stuff there.
They did.
No, he could have put it wherever he wanted to put it, couldn't he?
He was instructed to take his stuff to the end of the
Like
driveway.
they say, you don't have to go home, but you got to go someplace. You have to leave, and he was told to leave.
And he wanted to take his belongings with him, and he packed his
He
belongings.
didn't have a car.
And he arranged to be picked up by Chelsea Stakoska, and he was instructed, I believe, not only by the owner but by the police, to place his belongings at the end of the road, at the end of the driveway.
If he had wanted to, he could have taken them with him when he left, couldn't he?
When he was arrested,
No,
Yeah, that's how I left.
Right.
as he was leaving. If he had, if a car had arrived, he could have taken that with him.
yes, yes. And so, what
I think your big point is that this debate over, where they, like trash that people leave at the side of the road is, and correct me if I'm wrong, but is irrelevant, because when Officer Crevier got there, he knew from Officer Harden, whatever his name was, the other fellow, that these, in fact, were the defendant's possessions. Correct?
That's correct.
So he could have either left them there and said, to hell with it, or he could have did what he did, which is to pick them up with a view to take them to the station, right?
Correct, Your Honor.
Now, isn't the problem that once they were taken to the station, let's skip for a moment that he opened them, they would surely be opened at the station, would they not? This was just alluded to be inventoried.
If this had been an inventory search,
No, if they weren't, if Officer Crevier said, all right, these are the defendant's bags, he's now arrested and he's down at the station, that's where he was, correct?
at that time, yes.
Yes, so I'm going to take these bags with these possessions, and I'm going to bring them down there, I'm going to be a nice guy. I don't have to do this. Once they got to the station, they would open those bags, would they not? Inevitably open those bags.
But that presupposes a lawful basis for the officer to seize those bags and bring them to the station in the first place. And what basis did Officer Crevier have to return to the DiMarzio property and retrieve my client's luggage and television set and bring them back to the police station?
Safekeeping. He wants to protect the property from vandalism. There's a television set right out there, right out in the open.
Right. And again, Judge Roop made very specific findings about a number of things that were in evidence in this case that suggest that safekeeping had nothing to do with it. If this had been a safekeeping case,
Well, but that went to the police officer's actual motivation. I think that was her finding.
correct.
But the officer, in fact, had the authority to impound that property for safekeeping and take them to the police station.
I'm not aware of what that authority would be, Your Honor. Not. Excuse
It's just
me.
like they do with cars. Same thing, isn't it? When
But this is a circumstance, Your Honor, where where my client took step after step to protect his right of privacy in an extraordinary way, under the circumstance of being removed from his home, and including getting a ride and bringing his property to the next.
Argued only under the Fourth Amendment?
I'm sorry, Your Honor?
Is this argued under the Fourth Amendment exclusively?
As opposed to Article 12?
Correct.
No, I would argue both, Your Honor.
Well,
And
Why can't we just say that in this bizarre set of facts, because they are bizarre, very unusual, or at least unusual, what the police did was not unreasonable, period.
Be-
Forget all these, you know.
Because I think the appeals court equated vulnerability with, therefore, society is not prepared to accept this as objectively
I care
reasonable.
what the appeals court did. Why can't we say it differently?
Well, I
That's why
am
it's
asking
here.
you to say it differently, Your Honors, and I would respectfully say that under the circumstances of this case, and I agree, this is a very unique set of facts, that under the circumstances of this case, that society is prepared to say that my client still had a reasonable and objective
So
expectation
you would
of
say the
privacy.
police should have just left his stuff there?
Under the circumstances of
Yeah.
this case, certainly,
Just
because at least
For how
two,
long?
if not three of them knew that his friend was on his way.
So they just drive away, leave it there?
And again, if you look at United States versus Katz and all the progeny, it's not a matter of whether or not the police are exposed to a lawsuit, or is this a property right or a tort issue about whether or not they're doing the right or wrong thing by taking my client's property. The litmus test here is, did he have an objective and reasonable basis to believe that he was still maintaining his right of
So
privacy?
you say they should have left it there, and then anyone who walked by could open up his luggage?
But you, again, that's true, Your Honor, but the vulnerability is not the test. If the vulnerability is the test, then that's going to become, on a case-by-case basis, very difficult to determine what is still objectively reasonable and what's not.
You're saying that he had a reasonable expectation of privacy in the property, and that when the police went back there, they conducted a general search without
Correct.
probable cause.
That's correct. And if I can say one more thing, I know in Commonwealth versus Netto, the court talked about cases very similar to this in terms of things being left in a public location after somebody's arrest, and if they've made other arrangements, there is a restoration of somebody's objective right of privacy. And I would urge the court to consider this case in that milieu. Thank you very much.
Mr. Barton, Ms. Pizzas?
Good morning. May it please the Court, Judith Ellen Petrus for the Commonwealth. There isn't any Article 14 claim that was raised before the motion judge. In his motion, the defendant asserted the Fourth and Fifth Amendments in Article 12 only. I would say that there is a question as to whether there is any factual support in the record for the judge's finding that the police were fully aware that
She didn't say fully aware, right?
she said that they were aware that, including Crevier, that, one, the property was at the end of the driveway and that he'd made arrangements for it to be picked up.
But I'm just looking at, he moved the items in the back, he being the defendant, as well as a television, to that portion of the property, Mr. Brian. The defendant advised both Mr. DiMarzio and police officers that he needed assistance. I'm looking at Supplemental Appendix 10, so it's in the red brief. In removing his personal items from the property, and that he needed to place a telephone call in order to arrange for assistance. In fact, police officers did observe him making a telephone call, and Officer Harder overheard the defendant speaking with someone requesting that she pick him up at the address and pick up his items as well.
And there is nothing in the transcript that Officer Harder heard anything. What is in the transcript is that both Officer Harder and the homeowner heard the defendant say that he would get someone to give him a hand. They saw him on a cell phone. Nobody heard anything, so nobody knew whether his efforts had been successful. Sergeant Gagnon died prior to the hearing. We have nothing from him.
Yeah.
What
No,
we
but
do,
it's clearly about Harder, but
Right.
Harder did testify.
Harder did testify.
So if I
He
go
never
back and-
said he heard anything. He said, I saw him on the phone. More importantly, given the way the motion judge put these facts together, there is absolutely no record support for the fact that Crevier was aware when he left the premises that the bags and TV on the road belonged to the defendant.
Well, then why did he take him back to the police station? He took them back to preserve them for the
Right,
defendant.
that's part of my
Why would he
argument.
do that if he didn't think they belonged to the
No,
defendant?
what I'm saying is when he initially left the property, and that's where the illogic comes in the judge's finding, if in fact this police officer wanted to conduct and intended to conduct a general search of this, and if in fact the police officer knew at the time this property belonged to the defendant, he would have searched it and picked it up and taken it and the defendant back to the station at the same time. There was no reason to go to the station and come back, but for the fact that he was not aware that these bags belonged to the defendant who wanted to retain the property until he got there.
It seemed to me that there's another explanation. I frankly don't know which way it cuts. Again, I haven't looked at the transcripts, so I'm just looking at her findings. But I take it that the landlord, DiMarzio, at some point saw the bags and the television set at the end of the property, correct?
Correct.
And called the Ware police
Correct.
and said, the defendant's property is still here.
Come get it.
No, he said, what am I supposed to do with it?
And then his memory was refreshed by Mr. Bartman, and he looked at the statement that he had made, and he said, and I told them, come get it, which brings us into the Cifuentes case, where the motel manager says, that car is still here, come and get it.
Well, again, if the police have the defendant in custody, I mean, the fact that a citizen says to the police, do something, doesn't mean to say the police do it, right?
But that gets into the community caretaking, and that's why I'm saying that the record doesn't support the judge's finding that Crevier knew when he was on the property that this bag belonged to him.
I understand, but he knew when he went to collect it.
Yes, he knew then.
And so on what basis does he then, as I understand it, at the scene, he opens it?
Well, what basis does he open it? He opens it to make sure that he's not carrying anything that's going to harm him or the public when he's transporting it.
And so he's fumbling around inside the garbage bag looking for
a bomb?
disease?
He's not looking for disease. He knows that this defendant already has a prior conviction for a firearms
But I mean, a
violation.
firearm is, it's got to be a bomb, firearm. There's nobody to shoot the firearm.
It could be a hair trigger.
Could he be looking into it did he testify why he looked into it?
He looked into it for safekeeping, officer safety, make sure that everything was okay, see how heavy it was. He didn't, it's very, very clear, he didn't rummage through everything. He just went through, he felt one heavy pouch, he could feel a firearm in it. That he opened up and took out. It was a loaded firearm. He didn't go through the CD containers, the electronic games, the clothing. He didn't sort through pockets.
Testified to he opened it for his safekeeping and what else?
To make sure that he knew what he was carrying.
Would he be saying
He
there
said
to make
officer
sure that
safety.
it was this man's property and that he was not carting away somebody else's stuff?
It did not appear that he did an item-by-item search looking for identification to identify the property. Believe what the record would establish is that when the homeowner called and said, the bags are still there, come and get them, he knew that they were on a specific side of the driveway. What's important here is that Crevier says at the hearing that he's not told anything about the defendant's bags. Harder said
In the bag that would have harmed him.
could have been anything with this defendant.
So you can do that with a suitcase.
Anthrax?
True.
You're saying when a police officer is confronted with a
Snake?
suitcase, he can look inside the suitcase for protection of his own safety.
No, I'm not saying that. I'm saying that when you take someone into custody, you typically take their personal belongings with them. Now, typically, an individual may just have what's in his pockets, and you do a search on that. You do a pat frisk to make sure there isn't a weapon there.
A television set. These are his.
He didn't
furniture.
search the TV.
Ms. Peters, I understand. There's no question that, I mean, he's at the scene. He may not have recognized that these are the defendants, but there is a summary eviction. The police have been called. There's a conversation with the police and the landlord. The landlord says, yes, this person, the defendant, can go back in and remove his personal belongings.
His items that he claims are his, right?
Yeah, items that he claims is his, and they're two big plastic bags, or 2 or 3, and a television set, and they get put in a certain place.
Right.
I mean,
Do you agree that the inventory ground doesn't apply in this case for the reasons why the judge said it didn't apply? As I understand it, she says you can't rely on that because they didn't follow the inventory procedure.
Well, that would require an Article 14 review, and that's not it. For the Fourth Amendment review for inventory is simply that it's standardized routine procedure.
But you can't have it both ways. When he opened, and I'm sorry.
But you have to.
I'm sorry if my question is irritating to you.
No, I don't. I'm just trying to keep it separate in my mind.
At the time that he was opening the plastic bag and found the weapon, he was not doing it in order to do an inventory search. He was doing it to protect himself.
Correct. And the public, to make sure that he wasn't carrying anything that was volatile.
So
he puts the bags.
So it seems to me the inventory has got nothing to do with it. That when they come to the police station, he does an inventory, makes perfect sense to me.
To that extent, that's correct, because at that point, he finds absolutely nothing when he's going through the inventory search of documenting all of the defendant's property that the defendant is seeking to suppress. So, and I misunderstood the court. At that point, that's correct.
Even if he were, let's assume that he opened the bag, found the weapon, and then when they did the inventory, a careful inventory, it turned out that there was something else illegal, that the tapes had pornographic, whatever it is.
Mm-hmm.
It still seems to me to be perfectly reasonable for the police to do an inventory compilation. I'm not even going to say search, a compilation, if you take things back, because there's going to be a claim that there was a gold watch in the bag. So
Correct.
So it seems to me that once you've got beyond what he did at the scene, when he first went to, quote, retrieve the goods, anything that happened thereafter is irrelevant.
Irrelevant except for the fact that had he not opened the bags at the scene, had just moved them into the car, it would be inevitable that as the inventory was done of the defendant's property at the station, that the firearm would have been discovered. So I guess to that extent, it's not completely irrelevant, but I understand now what the court is saying, that up to the point of discovering the firearm, that was not the inventory search, because that happens at the station.
When we do, what does our case law say about that? If it is in fact, or if it's, can you have inevitable discovery and the inventory rule requirement? Are they incompatible?
They're not incompatible.
Do we have any case law that says that?
I'm not aware of a Fourth Amendment case that actually deals with the inevitability and inventory search. I'd have to, because to be honest, I have not considered that.
You don't
in my
argue
analysis of
inevitable
this.
discovery, do you?
We do. I do make the statement that it would be inevitable, that it would have been discovered at the police station. I think my concern more is that the court understands.
Because that would sort of take the guts out of the whole inventory requirement.
Well, it's not.
That you have to follow a written inventory procedure, and because otherwise the Commonwealth could say, well, if we had an inventory procedure, or if we had followed the inventory procedure, it would have inevitably been discovered.
And we did have a written inventory policy, and there was compliance with the procedure, albeit the judge found that it was imperfectly as far as the reporting, the property receipt. So, but then that's a different argument that the Commonwealth makes as far as invalidating what had transpired. But the factual record just doesn't support the judge's finding that the police were all aware of this and that the homeowner was aware of it.
If the police were all, if in fact, I mean, the appeals court accepts all of those findings and says, nevertheless, because it was left on the side of the street, no expectation, no objectively reasonable expectation. Do you agree with that?
I agree.
So homeowner has been evicted, packs up big boxes of stuff, puts them out on the street, the moving truck is coming to pick them up. The police say, left it on the side of the street, gotcha.
No, we don't have a homeowner, and we don't have an eviction.
Being evicted, someone being evicted.
Well, he's not. I think evicted implies that you've got a tenancy right. This person was a trespasser who did not live in the trailer.
The appeals court is saying, I accept this is, the court says, we accept that this is his stuff, we accept that he wrapped it, it's trash bags, but we are treating it as though it was Vuitton suitcases, and still...
And we accept someone's coming to pick it up.
And we accept somebody's coming to pick it up, but still...
Well, because, and that would be accurate under Fourth Amendment law, that you can retain a property interest in an object, but you can relinquish any expectation of privacy with what you do with it. And here what he did, which I think brings it back into the Greenwood case, so it's somewhere between Greenwood and Cifuentes from the perspective of the police.
But he was arrested.
But what does...
He was standing with his property.
No.
He wasn't?
When he was arrested, he was not standing with his property.
Was he going to leave his bags there? Is that
He
the
called
record?
someone to pick him up? and-
No, he didn't. He wasn't arrested until Officer Crevier came. At that point, all of the bags, all of the property was at the end of the driveway, and everybody is unanimous that Officer Crevier comes after all the property is up on the road
No,
and the defendant's in the driveway. That's when he's arrested. He's not arrested with his property.
Yeah,
But he's just let's say he hitchhiked a ride from Massachusetts, from Maine, and he stopped, and the person who he hitchhikes a ride with lets him off in front of this same person's house. He's standing out there with his bags. A police officer, his garbage bags full of his property. A police officer comes and says, "Geez, I recognize this guy. There's an outstanding warrant for him." He arrests him, and the property is left there with the bags. Isn't that effectively what we have here?
It is, because at that point, if you assume in your fact pattern that the officer arresting him doesn't know that's his property,
Yeah.
otherwise he normally would have picked it up
Because
with
he
him.
did not involuntarily walk away from those bags and abandon them.
Oh, no, and there's no claim of
He was taken
abandonment.
by the police away from his property,
That's correct.
without his property.
Ms. Peters?
But without his property inadvertently, because there's no evidence that indicates that Crevier knew. The best that Harder can do is he says, "I think I told him," but I don't remember exactly what he was told. But Crevier says, "I was told nothing."
Can't we just recite this bizarre mess and say what occurred was reasonable?
Yes, and it is reasonable, because the police acted very
Let
reasonably.
me ask you this question. Since it applies in other cases that what one police officer is known by all, if one of these police officers knew that it was his stuff, doesn't that bind Officer Crevier as well?
Well, I'm not sure that the collective knowledge doctrine has ever been invoked in this regard when it's clear that the motion judges, the appeals court referred to it, buttressed her conclusions of law by her finding that everybody, including Crevier, knew that that was his property. It's just so illogical on the face of it that
think we've
Crevier
been
would
very
move to
careful
protect
in-
his property if he had known at the time.
Careful in the last 10 years up here to not rely on that collective knowledge doctrine, because it's impractical in this day and age.
Well, sometimes for probable cause, I think it may still be available, but it is difficult. I would agree, and certainly for purposes of this, then I would welcome the fact that the court would not want to rely on it. But the record contradicts here that Crevier had any knowledge. And even if it was a fact that the motion judge did not believe Crevier when he said, "I didn't know about it," you know, there's not enough in Harder's testimony that gets her to the factual findings she made.
Ms. Petzos, can I ask you this question? I take it that if we look at the record, the Commonwealth, we would find that in these circumstances, inventory at the police station would have occurred.
Correct.
Okay. Are there cases one way or the other, and I really can't, I just don't know at the moment, where we could conclude that opening the bag, community caretaking function, is, we've also been rather careful to constrain, that, I mean, the officer, if he didn't know if it was safe, could have said, "I don't want to pick them up, I'm going to call the trash company," that we could conclude that what was done at the scene where the bags were picked up was improper, but that had he just done nothing there and taken them to the police station, the inventory would have revealed it. In other words, I don't know, are there cases where when you find that the initial police action violated, in this case, the Fourth Amendment, but in fact, if he had done what the only other alternative would have led to the same result. Are you with me?
Yeah, I believe so. There are, in fact, cases that the name of any of which I can't recall right now that do indicate that because of what an officer did precipitously may have been incorrect, the inevitable
Are those in your brief?
No, I did
don't-
not get
It would be helpful
into that.
if you have such cases, or the opposite way, because it seems to me that looking at what's reasonable, I mean, there are two things that are happening here. What does a case stand for a proposition about garbage bags in these circumstances, and also, what's the practical result of what happened here? So they two, at least in my head, I see them as two slightly different issues.
And the one thing that I want to also make clear is that the judge never found that this defendant resided there. Her statement was that he stayed with some degree, unspecified, of regularity.
At least for me, that's not relevant.
Well, I think the way the FAR application went, it was that this now had universal impact on all those who were homeless, and the defendant relied on a Connecticut case with a homeless man. But there's no finding here that he was homeless. There's no finding that he lived there. He was at some point a guest when he was in the area.
Sure, no, I understand.
And so I think that
He
puts a
wasn't
different
homeless.
context.
His girlfriend was going to pick him up and take her over to her place.
And she had also testified that almost all of his belongings were already at her home. But to the effect that that gives a context that may play more emphasis.
But you understand that the problematic part, if there is a problematic part, and people may disagree with the appeals court decision, is it basically said, notwithstanding all of that, because it was left on the side of the road, the objective reasonableness is relinquished.
Well,
And so that is a broad principle that will apply in lots of areas.
but that's
To
Greenwood.
people who are evicted or
Well,
otherwise in between houses.
it's Greenwood, maybe.
That is Greenwood, where, you know, now there, the individual had the intent to relinquish his property to a third party, you know, albeit he was abandoning his property. We agree there's no abandonment here. Here, the defendant brought it up and placed it on a public road with the intent to relinquish it to a third party, albeit his girlfriend. But the fact remained that that was a public road. And so therein you fall into Greenwood. And then the return, I say, is controlled by Cifuentes, and, you know, so there we are. But I will look for case law on that and submit it to the court in a letter.
Thank you very much.
Thank you.